I'm Natasha Chilingarian.
I'm Michael Ogden. This is Shared Accounts with CU Times. Breaking news pod. As of this recording, late yesterday, Tuesday, federal judge Amir Ali ruled that President Donald Trump acted unlawfully in removing NCUA board members Todd Harper and Harper-Otsuka, and the judge ordered their immediate reinstatement. So, as expected, the Trump administration did file its appeal of the ruling Tuesday night. The judge has said today he got that motion. And we wanted, though, to talk about this news, break down some of the issues with our returning guest, Elizabeth Eurgubian, partner at Atlas Advocacy in Washington, D.C., and former director of external affairs and communications policy advisor at the NCUA. Elizabeth, so glad to have you on such short notice.
Hi, yes, thanks for the invitation. I'm glad to be here.
Glad you're here.
Yes, thanks so much, Elizabeth. We're excited to have you here amid this really big announcement. Let's just jump right into it. So we do have some pretty specific questions about what this all means, but just on a personal level, wanted to find out, what was your initial reaction when you heard the news yesterday about the ruling?
I wasn't surprised. I was actually on a plane when it came down, and then when I landed, it was a cross-country flight. When I landed, I just looked at my phone. I'm like, oh, stuff has been happening when I've been in the air. I wasn't really surprised because it's just the way I read and interpret the Federal Credit Union Act as to the structure of the board and why that particular structure was chosen and the intent behind it. It just was very clear to me that these individuals couldn't be removed except for cause. But I mean, that's my opinion, but the court has to make their determination. But it was consistent with what I thought the decision would be.
Okay, so let's talk about the legal significance here of Judge Ali's ruling reinstating Harper and Otsuka to the NCUA board. What's significant about that here?
Well, I think it's significant because the court does really show this is a different kind of agency. It's an agency that does other things that aren't just solely like executive functions. It has, quasi-judicial and quasi-legislative functions that make it different than like Department of Health and Human Services or one of those types of departments that really advises the executive office. This agency doesn't really do that. That's not really the function. It has really independent functions. And also, that's why the statute was written as it was, to give its members staggering terms and making sure only two are from the same political party and that only one comes directly from the credit union industry at most, and that they're all qualified in financial services and have some sort of background in that. So, I mean, the statute made that clear, and also just by the function of the agency, it's really a quasi-government independent agency. It's different than other agencies. And the court reaffirmed that distinction, that this is a different animal. It's a different kind of agency, and it's going to operate differently, and the president's going to not have the same authority that he might have over a department that is in his cabinet and that advises the executive branch.
Right. So can you walk us through, because basically what happened here is the judge interpreted the NCUA statute to conclude these board members are protected from at-will removal. How do you think the judge went about that? How did they interpret this statute?
Well, there had been some folks that say, well, the statute doesn't expressly state that they can't be removed by law. Now, in law school, when you show up to class, they teach you, of course, you look at the statute. You always go to the plain language first. And then the plain language doesn't always give you the exact answer because Congress didn't have a crystal ball when they were writing the statute. That's why lobbyists are so important. You have to foresee issues down the line and make sure those are addressed in the statute if you can do that, which is always difficult to do. So when in cases like that, you go to the legislative history, you try to see what did Congress intend when they wrote the statute. Well, in the beginning, when you had an NCUA, I think the NCUA has celebrated its 55th birthday this year, established in 1970. Before, you had one administrator of the NCUA after 1970. And there was language in there that said that administrator served at the pleasure of the president. Well, they went back and revisited that a couple years later and took that language out. And then allowed for a three-member board with fixed staggered terms, 6-year terms, so that they would be staggered. They were, only two from the same political party. Only one could come directly from the credit union industry, immediately from the industry, and they had to have qualifications in financial services. And also in that same piece of legislation, they expanded the NCUA's authority to have a liquidity facility, the CLF. So, the NCUA has a lot of power. It has a share insurance fund, it regulates all credit unions, and it also has this big liquidity facility, which is an enormous responsibility. And it makes sense that a 3-member bipartisan board would be in charge of that. So, and the court addressed this. It said, look, they took out the language at the pleasure of the president. They took that out when they made these changes. Well, did they do that just for fun, for kicks? No, they did it because they didn't want the language in there. They didn't want that to be the reality for the new board. So those are the types of indicators you look at when something isn't expressly stated in the statute. You look at, why was the statute changed? What did it look like before? What did they take out? What legislative history supports those changes? And there was legislative history that supported the reasoning behind those changes being made. And all of that pointed to the fact they wanted to have an independent agency with a board that was kind of apolitical.
No, I appreciate all that. And I would love to see if there's any asterisks on any deletions made, to laws of just asterisks for kicks. We just did this for fun. But I want to ask, you made me so much smarter the first time we spoke, Elizabeth. You were talking about Humphrey's executor. And I dove into that thing. And now I can talk about it like at cocktail parties. But what precedent did the court rely on this ruling? Was it Humphrey's?
Yeah, they looked at they looked at a few cases, and of course they looked at Humphreys with the FTC and, saw that the NCUA operated very similarly to the FTC in that case. They kind of made a distinction with this other case, the Severino case, where in that instance you did have an entity that was advising the executive branch, which the NCUA is not. It's not serving in a capacity that's advising or helping the executive branch with decision making. And that's it. So it made that distinction using that case. And then, of course, said that with the Seal of Law case, with regard to the CFPB director being removable at cause, it made the distinction there that this is Humphrey's executor law is still good and it's still valid for purposes of this decision, even with the Seal of Law case, because, again, that was a different agency. It has one director making decisions. It has a more politicized agenda, and just the structure of it was different than what you're seeing with what the folks that wrote the statute wanted with the NCUA. So all of these agencies, there's this nuance there. And I would read articles where people say, well, Seal of Law happened, so of course it's going to be that same with the NCUA. I'm thinking, the NCUA is a different agency. There's nuance there. It's subtle, but it's there. And the court, made those distinctions in its decision.
Okay.
Right.
It's not black and white. I wish it were black and white all the time, but because it would make our lives easier. But there is some gray.
But also, if it were black and white, honestly, it might be a little bit more boring.
Right.
But I understand what you're saying. You just want a clear damn answer.
Right. And it makes everyone feel comfortable because we love answers. It makes us feel warm and cozy.
We like
inside.
boundaries. Yeah.
Right. But there is some nuance. And it was also important because based on this decision, you see where the court's headed in their thoughts on what the Federal Reserve is.
Yeah.
Okay, so Elizabeth, looking just a little more broadly here, leading up to this, the Department of Justice basically was arguing that the NCUA board was exercising too much executive power, and that the president should have more executive power than the NCUA board. So now how does this ruling, essentially against that idea, how do you think that affects the president's removal authority overall in the eyes of the law?
No, that's a great question. I think it definitely gives power to the argument that he can't remove the Federal Reserve chairman, because again, that structure, that board is very similar to what the NCUA's board is. And this court even recognized that. So I think it's, for certain types of bodies, for certain types of agencies where it's maybe one director or they do more advising of the executive or providing feedback to the executive branch, that he would maybe presumably have more authority in removing those folks. But for an independent agency that really has all these other functions like adjudication functions, examination, collecting civil money penalties, legislative functions too that are not just executive-based functions and that are run by a multi-member board, that's a more difficult argument to make that they're an executive branch or an extension of the executive branch giving him that authority. It's just, they're quasi-government agencies. They're not, we're taught in school that there's 3 branches of government. And I remember when I started working for the Fed, I was only 26 or something. I was like, well, the Fed, and they're like, the Fed is quasi-government. I'm like, what the heck is that? I'd never even heard that expression before. So there are these sort of like different kinds of entities that kind of encapsulate all the branches in some regard and are independent. They're independent agencies. They're really not a part of the executive, judicial, and legislative. And I think in this case, the executive branch was trying to kind of grab them a little bit and have more authority there so they could have more control over the folks that are leading those agencies. And the court said, no, I'm sorry, you can't in this regard.
So what do you make? And obviously that answer, we could dig in for an hour to that particular issue because that seems to be really the crux of all of this.
Yes.
The presidential's power. But I need to move on a little bit more because I want to ask about your thoughts on the Department of Justice's claim that Congress must use very clear and explicit language to limit presidential removal power.
I mean, you could say Congress needs to do that in any regard. I mean, when you look at statutes, typically the way the courts will determine what they mean is by first going to the plain language. And when that's not really clear, then they start to look at other indicators. Because like I said, Congress can't foresee every question or issue that's going to pop up when they write these things. And you see what goes on when they write these pieces of legislation and then become law. I mean, even in the most recent issue, half the members said they didn't even read what they passed and were confused by it.
Exactly. Yeah.
So it's a mess. I mean, it's like making sausage. The process is, I wish it was streamlined and beautiful and parsimonious, but it's not. It's kind of a disaster. And you just throw everything in and you kind of hope for the best. And I remember working on legislation too, on that side where, we just kind of threw things in and just said a prayer and hoped that things worked out. There's not as much thought put into things as you would like. So, and I think the courts understand that. So they look at the plain language, but when they don't get it perfect, because it's impossible to, they start to look at other indicators as to what Congress meant and what they intended when they passed that legislation. And I think there's a big, powerful argument that when you take out the words at the pleasure of the president, and you take those out, that there was a reason behind taking that out, because you didn't want that same structure for the board moving forward. So
now in this appeals process that we are most assuredly heading down that path, if the DC Circuit or even the Supreme Court upholds Judge Ali's ruling, what precedent does that set for other independent federal agencies?
The same situation where you have, it's not going to be the same for every independent agency. Like I said, it depends. The court makes the distinction with the FTC versus, other agencies that really had more of an executive advisory function. There's a distinction between the CFPB that was operated by one individual versus a board that in the statute, it goes out of its way to say it has to be bipartisan, it has to be staggered terms. And then what functions do those agencies have? Are they doing adjudication functions? Are they doing like legislative type functions in addition to executive? So all of these things play into the decision as to whether this is more of an independent agency or whether this is more of an executive type of agency. So I think it would really depend on the agency. I think for purposes of this decision, your financial services agencies like the FDIC, the Fed, and NCUA, those three agencies seem to sort of be similar. So I think the same arguments hold for the NCUA as would for like the Fed, for example. But it really depends on the agency. I think that's what this has shown.
Right. And can I ask, do you believe this case is headed for the Supreme Court? I know you don't have a crystal ball, obviously, but what are your feelings about that?
Yeah, I think it's definitely a possibility.
Oh,
Definitely a possibility that they would hear it. And I know they've opined a little bit, their last decision on the Federal Reserve, saying, and when that language, they cited that language in this case, when that language was put in, I think it was the Chief Justice Roberts, who said something about, with the case with the Federal Reserve, that's an independent agency, making that distinction. And I thought to myself when I read that, okay, well, they're going to make the same argument for the NCUA because they're pretty much similar. They're almost exactly in functions very, very alike, except one's for credit unions and one's for banks. Now, Fed has more broader powers in terms of monetary policy and whatnot, but they're ultimately pretty similar. Also, there's a public policy argument here. Courts will look to policy as well, which this court did, in saying that, look, these guys are regulating your money. I mean, there's a share insurance fund, there's liquidity stuff, there's examination. I mean, there's a level of independence that you really want when someone has control of your money.
Oh, yeah, you would think.
Great point.
At least I do,
Oh, yeah, I know, this is risky, yes.
I think we all agree on that one. Elizabeth, I want to ask for those of us who are following this case, credit unions, regulators, journalists, those of us just interested and invested in this case, what should we be watching for as this moves forward?
For those who are paying attention, I think it would be interesting. I mean, I'm going to watch for how the board reacts. Like, what's going to happen? Are these guys just going to show up to work?
Yeah.
And I mean, are things going to go back to the way they were before? Is the president going to try to remove either board member Otsuka or board member Harper for cause? They didn't argue that in
Yeah.
the case. They sort of went for it didn't matter because he could do it regardless. But is he going to try to figure out a way to remove them for a for cause reason and put somebody else in their place? So, how's the agenda going to be set? Also, the NCUA is unique. And I mean, I understand why the administration did what it did, because you have a unique situation with the NCUA board and that you have the chairman that is the political party of the president, but he's in the minority. You have two other
Yep.
members on the board that are Democrats. So there's only so much he could do if he doesn't have at least one of them voting on the same side as him. And the administration, that's not favorable to maybe what they want. They want to have more control. So I think how the board is going to function moving forward, you also have the chairman of the board whose term is up, very, very soon. I think next month, in fact. And is he going to stay, or is he going to be replaced, and who's going to replace him? If he steps down, does one of the other board members, and there's no replacement, does one of the other board members who then is a Democrat become chair? So there's a lot of, I think, in terms of how the administration of the agency will operate, I'm going to be paying attention to that.
And it does feel like, we have a number of open questions because as, again, of this recording, tomorrow is a board meeting. Yeah. Will Chairman Howman address this at all? Will Harper and Otsuka show up? How is this going to function, to your point? But the way I am looking at this, Elizabeth, is a mix of a soap opera and a game of chess.
Yeah, right.
It's a weird thing to be watching, and I'm very, very thankful for your thoughts.
Yes, I agree. And, if you're a lobbyist, like I said, it's irrelevant. Like, I'm a lobbyist. I do regulatory, legislative. And to me, this was like, it's fun. It's academic for me because it kind of distinguishes where I'm who I'm meeting with, or I'm not meeting with anybody at the NCUA right now because I have a ban for another few months.
Right.
But it's academic because if you are a lobbyist, you are friends and you are talking and educating everybody. It does not matter who they are. It does not matter if they're fired. It doesn't matter if they're coming back. It doesn't matter if they're going somewhere else. It doesn't matter. Everybody is someone you're lobbying and educating and being friends with and doing things for. And because even if they leave, they might go somewhere else. You're going to need them there too. It's sort of like academic, like, okay, well, that's nice. He's not there, but it's really like shuffling the deck chairs on the Titanic. You're still doing you're still doing your job regardless. And so people are like, what does this mean? I tell them, what does it mean? It means you still got to do your job. What does it mean when everyone goes away? It means you still got to do your job.
Yeah.
So.
Well, it's going to be interesting for sure, especially in light of this board meeting coming up. I just am dying to know what the mood in there is like right now and how tomorrow's going to unfold. I mean, exactly. I don't see how you can just go back like pretending that this never happened. I mean, you could maybe on the surface just, okay, let's just move forward, but this has never happened before. So it's going to cloud something.
Yeah, it's like you're having to go to prom with the person you broke up with 3 months ago.
Yeah,
right. And I gotta say though, just working with all three of these board members, I work closely with former Chairman Harper, saw the other board members as well. They're very professional.
Oh, I'm sure.
Oh, yeah.
But Chairman Hauptman he's professional. He's very cooperative. I mean, he had a great working relationship with both board members, both the other board members. They all did. I mean, they might disagree, but they're professional about it.
Yeah.
And when they could agree, I saw times where they were able to reach agreement on issues and negotiate issues. And that was the happiest you ever saw those three. Like when they were able to come to consensus on something, they were like, wow, we were able to get through this and work through it. Now, that's not as fun. I mean, we kind of like to see a mud fight. It's always fun from the crowd.
Yeah.
But it's just not. I mean, It just wasn't ever like that. So, I mean,
Yeah.
if any
Yeah.
board is going to kind of get through a situation like this, I would say it'd be these three folks.
Nice. Okay.
Great to hear.
All right. Well, and when we're dealing with people's money, I think everyone can agree we want professionalism over a mud
Yeah,
fight.
I like the drama on my reality television show.
Exactly,
I don't
yeah,
like
save it
it
for
when
that.
it has to do with the money I'm putting in my bank or credit union.
Absolutely makes
No
sense.
drama
yes.
there. No drama there.
Right. Okay, well, thank you so much, Elizabeth, for all your insights on this critical situation here. But before we let you go, we have to ask you one other really important question, which is, how are your dogs Sunny and Bear doing?
They are good. You might have heard them in the background, and then they were
did,
making
yeah.
too much noise, so I let them. I usually put them back, but you guys asked about them, so that's why I kind of let them roam around. But then they started
we
making
love
too
that.
much noise, so I kicked them
Oh,
out.
well,
So I think they went
dogs
to
are
another room because I kicked them out.
okay.
But they're doing very
Yeah.
well.
We
Yeah.
love them and think about them often. So,
That's good.
great.
love
Elizabeth,
yeah.
thank you so much.
Thank you
Yes.
so
for
much,
joining.
Elizabeth. Appreciate it.
Anytime.
Yeah.
We really appreciate everything there that you have given us and taught us. And then same goes, for our audience, what you're sharing with them. So obviously, everybody, this story will continue to develop. Keep an eye out for our reporting on cutimes.com and here on Shared Accounts with CU Times. For now, we got to get back to work. Take care of yourselves. And thanks for listening.